Good.
Why?
Not sure. We're not going into that right now.
Okay. Tell us, or tell us, who you are.
Okay. I was born in Corpus Christi, Texas, and I was told you're wrong and then you'll die. Oh, excuse me, that's what my wife says. Now, I was born in Corpus Christi and raised there to I guess what you would call a lower middle class family. My father was a government worker and went to school there. There were some things in my life that I would have to say were life-changing sort of events, kind of made me who I became, for good or bad. I've always been sort of a overachiever type. It's an Eagle Scout.
What?
I played high school football and was an all-state high school football player, which probably more than anything else taught me that endurance and hard work pays off, and that you have to suffer a little bit. And it taught me the value of teamwork and made me a more aggressive person from the standpoint of the way I approach things.
Now, when you said you played high school football, that was during the era when you had August tryouts and
Yeah,
you didn't
yeah.
take any water breaks, right?
Corpus Christi, Texas, in August, we're talking maybe 98 degrees and 100% humidity, and yeah, it was a painful experience. You ate a lot of salt tablets, but and then I went on. I went to the University of Texas, and when I went to undergraduate school, my goal plan was that I would become a professor of government and politics. I wanted to be a college-level teacher. But then I saw how these guys lived and how much money they didn't have and how hard they worked, and I decided that was not really very attractive. So I'm sort of an accidental lawyer. I had a double major. My major was government and psychology. And sort of on a lark, I took the LSAT. And I was going to summer school to pick up the 6 hours of statistics that I needed to finish off the psychology degree. I'd already got my government degree. And then I got my LST results back, and I got accepted to the University of Texas Law School. And hey, who needs statistics, right? So I went to law school, which on the whole I would have to say was a miserable experience. I did not like law school. It was horrible. I mean, I started law school, in 1968, kind of the height of the Vietnam War. We had a huge freshman class, or first year class, because they expected a lot of us to get drafted. And so I think that had something to do with why I got into the University of Texas. But I just, it was really an off-putting experience. I mean, UT at that time was just a business school. Contracts, property, civil procedure.
So the school, even though it was during the 68, the civil rights era, the Vietnam era, the law school did not have that kind of atmosphere of being...
We'll get to that. Yes and no. I mean, the core curriculum there was designed to grind out lawyers to go to work for big law firms. The Vincent Elkins, the Becker Botts, and that sort of thing. And very frankly, I don't think I would have finished law school but for two things, and actually one thing. In my first year, I got involved in moot court competition. And it clicked in my head that, this is going to be okay, because I'm just going through an initiation here. And at the end of this initiation, I get to be a lawyer. And at the end of this initiation, I can be an advocate. So the moot court competition probably kept me in law school, because if it hadn't been for that, I wouldn't have continued. I just didn't. I didn't see myself practicing torts law or contracts or business associations. It just wasn't me. UT didn't have any trial practice or trial-oriented courses. I mean, you had criminal procedure and criminal law, and that was it. Except in the last year that I was there, John Sutton started a trial advocacy seminar. And again, this is where something clicked, and I went, oh, this is what this is about. So that's it. And I graduated, and I became a lawyer. I'd never lived in Houston in my life. I'd been there for maybe one half of one day. And but I knew, this is a big town. This is the biggest town in Texas, and this is where I can do what I want to do. And so I went ahead. I had gotten married, I think, in the middle of law school, and moved to Houston. Went to work with a small law firm that did family, criminal, and some business-related stuff. And so I began practicing with them, and I stayed with that little firm for about 14 months and decided, hey, I can do this on my own. And myself and one of the other associates broke off, set up our own little shop, and it was called Bires and Valdez. Pretty soon we were joined by a fellow by the name of Will Dickey and another guy named Gordon Cooper. So we had a sort of a rainbow law firm. We had two white guys, a black guy, and a Chicano. And by and large, myself, all I did was criminal law and family law. And after about 5 years, I'd had all I could stand of family law. And so became strictly a criminal defense lawyer. And I have a sort of a basic philosophy about what it is that we do and why we do it. And I've enunciated this in some of the voir dires that I've done over the years with some pretty interesting responses from the veneermen. I think that as a society, we can withstand the very worst that any individual or group of individuals can inflict on us. I mean, take 911, the 19 hijackers, despicable people who inflicted a great amount of damage. And of course, our response to it has been pretty horrible, in my opinion. We've squandered any sense of support that we initially received from other governments. We've squandered our credibility. We've reacted badly. We've initiated a war in Iraq that has no meaning and bears no relationship to the, quote, war on terror. I mean, I think that we had to respond to the attack, and the appropriate response was in Afghanistan, and everything that has come since then has been a disaster. But
does that include the Patriot Act?
And that certainly includes the Patriot Act. But my point is that you can take the Charlie Mansons, you can take the 911 terrorists, you can take whatever group you want to take, and the worst mischief they can work on us. We can survive that as a free society, but what we cannot survive and remain free is official oppression. And So, I think we have the greatest job in the world, which is to, of course, challenge government in trials on a daily basis to make sure that the Constitution of this country has some meaning. And without us, I think we'd all be in serious trouble.
You said that the 4 people in your law firm that you started, you broke off initially. Did you take appointments?
Yeah, sure did. That's how I really got into becoming a criminal defense lawyer. I mean, heck, I didn't know anybody in Houston. And there was only one way to get business, and that was to go down to the courthouse and let all those judges know who you were and give them your card and keep coming back until they threw you a bone, and then work on those cases. And I was telling Lydia earlier that I did that. Yes, probably I've been doing this for 37 years now. And it's probably been maybe 20, 25 years since I've handled a state court-appointed case. And up until about 6 weeks ago, I had never handled a federal appointment. But I got tagged by Judge Francis Stacy in Houston. I happened to be there talking to a client that wanted to hire me at his initial appearance, and there was some young fellow that was in custody, and I guess I was the only warm body in the room. So Judge Stacy asked me if I'd represent the guy, and since I had declined on several previous occasions to do that, I said, okay. And so I took my first federal appointment, and I got that case dismissed in 3 days, which sends a real bad message. Don't judge it was a fluke, please, no more. But, so yeah, no, I began by hustling court appointments.
You talked about your philosophy. What would you say to young lawyers who are coming out and taking appointments? What would you say to them?
It's a different world. I mean, when in Houston, and of course I can only speak from that perspective. In Houston, back in the olden days, when I first started in '71, you got court appointments by doing exactly what I said. You went to the court, you gave them a card, you kept coming back until they finally got used to your face, and to get you away would just go ahead and say, okay, take this.
Brought donuts to the court coordinator.
Yeah, absolutely. Donuts to the court coordinator and whiskey at Christmas time. And so, you know, you got your court appointments that way. So it was a real kind of ad hoc, good old boy sort of thing. I mean, look, when I started practicing law, there was exactly one female assistant district attorney in the Harris County District Attorney's Office. There were no female judges, and there were maybe 2 female criminal defense lawyers, Joe Keegan's, and she's still out there, and
Clyde?
was a big name.
Clyde?
No.
Jan Nippon?
No, Jan wasn't around then. Marion Rose. Okay. And that was it. There were no women in the courthouse. You know, so it was a guy's game. Which, you know, that kind of colors the way the game is played. You know? So that was a major difference between then and now, and we'll talk about how that plays into my experience with TCDLA a little later. Kids now, Well, the system is entirely different in Houston now, you know, and you've got the Fair Defense Act, which is an attempt to deal with the inequities and arbitrariness of the court-appointed system, and doesn't do a very, very good job. And we're talking about an early attempt to try to do better through the Harris County Criminal Lawyers Association. Nowadays, in Houston, the hot topic, the real hot button issue in the courthouse is, do we want a public defender or do we not want a public defender? And for instance, within the Harris County Criminal Lawyers Association, of the presidents and past presidents, there's a real split in what people think should happen, should there be a public defender or not. I personally believe yes. I think that a public defender's office would provide a degree of independence to criminal defense lawyers who are representing indigents that doesn't exist right now. The average method of defending indigents in Houston, Texas, in Harris County is there are what are called contract lawyers who staff the courts, and you might say that it's somewhat of an ad hoc public defender system, but the judge chooses who those lawyers are. The judge chooses how much he'll pay those lawyers. The judge chooses how much money they'll get for investigation and expenses, and so that shouldn't be. The court should not have their thumb on the back of a criminal defense lawyer. Now, let's go back to when I first started practicing law, and I was hustling court appointments. You know, I represented my clients, and as soon as the judges figured out that I represented my clients, I quit getting court appointments. You know, when you're taking your cases to trial, you're bogging things down. Why are you trying this case? Well, because he's not guilty. State can't prove it. But, you know, I mean, counsel, can't you work this out? Judge's favorite words. Why can't you work this case out? You know?
You won't dismiss it.
Well, so, you know, pretty soon, if you were aggressive in representing your client, you didn't get court appointments, with a few exceptions. You know, there were some judges that actually did appreciate a good job. And so those guys, when it came to a serious case, would go ahead and appoint somebody that they knew they could count. That's a real uneven system, though, and it's given us some atrocities. We all know about the sleeping lawyer and the various things that occurred in Harris County.
According to the Fifth Circuit, that was trial tactic.
Hey, you know, not a biggie. He was sleeping when it wasn't important. But the kids now have to deal with a kind of closed system. Fair Defense Act requires that they be qualified in order to handle a case with a certain degree of difficulty, which I think is a good idea, but it makes it harder for a youngster to come in and do what I did. Essentially, you can't come in and do what I did anymore. That can't happen anymore. Because now, if you're a kid fresh out of law school and you come in and you try to get court appointments, the first thing you run into is, well, you're not going to get a felony appointment, period. So then you have to go to the misdemeanor courts. And although the misdemeanor courts don't do the contract lawyer situation to the extent that the felony courts do, they have like lawyer of the week. And so you've got to get into that line, so to speak. You've got to get into the rotation. And you're not going to get appointed to individual cases, and really, in those misdemeanor courts, there's atrocities being committed every day by the lawyers of the week, because the only reason they're there are to move cases. I don't think any of them have ever tried a case that I am aware of. And so it's a plea mill. I mean, people come in, they've been in jail overnight or for a week, and the very first thing that happens is they're offered a plea for back time, and most of them are going to take it to go home. And so they get stuck with a theft conviction when they're 17 years old, or a drug conviction, or a weapon conviction, or whatever it is. And we have in my firm now, Bires and Schaefer, in my firm now, 713-228-8500. In my firm, we do a lot of trying to undo some of the damage that has been done by the lawyers of the week who haven't even looked at the facts of the case, who haven't done any investigation, who essentially have conveyed an offer for a plea of guilty to somebody who, might be innocent. So that's the problem that you have with, you can't do what I did. Now, let's go back to the Fair Defense Act for a minute. Assuming that you can get into a felony court, assuming that they don't have contract lawyers who handle all of their indigent cases. And some of these contract lawyers actually try cases. I mean, and some of them are okay, pretty good litigators. Not the best, but providing competent representation.
They could benefit from the criminal trial college?
Oh, yeah. Oh, yeah. But assuming that you can get around the kind of the embedded team of lawyers who represent indigents in that court, Mike McSpadden's a good example of the way that system works. He has a team of 3 lawyers who represent all of the indigents in his court. They do try cases. They just got through trying a horrendous capital murder case. But that kind of inbred thing where it's the same people day in, day out, to me is somewhat of a problem. I mean, I don't know, if we go to a straight public defender system and you have a group of defense lawyers who square off against a group of prosecutors who are assigned to that particular court, pretty quickly you devolve into that same plea mill. I mean, just the kind of the familiarity breeds not contempt, but
mediocrity
a sort of mediocrity would be a fair way of stating that. But now again, way back, and this must have been mid-1980s or so. Joe Keegans was the first female district judge in Harris County and probably Texas. I happened to have been, I think I was president of the Harris County Criminal Lawyers Association, or the next guy, president-elect or something. I think I was president. And we put together a system, and we did a kind of a trial for 90 days in 3 courts. And what we did was, anybody who wanted to participate in this court appointment program could. We had a committee that rated their competence. So we kind of decided what level of cases these people could handle. And then we put together a rotating list, and we got 3 courts to agree that for 90 days they would follow this system. Well, of course, the experiment lasted exactly 90 days, and that was that. But there for 90 days, we tried to create a more fair system that wasn't cronyism, that was a rotating list, in which we tried to achieve a certain level of competence on the various types of cases that defense lawyers got appointed to. So that was an early attempt in Harris County to deal with that issue of adequate representation for indigents. And it was open to everybody. And everybody had an opportunity because the judge was committed, the 3 judges that did this, committed that instead of appointing their buddies, that they would follow the list. They would take the next name up in rotation that was qualified to handle this particular case. Well, we can't sell that in Houston now. So indigent representation in Harris County remains a problem. It's a real uneven system. In part, there's still a great deal of cronyism. Some of the courts do the ad hoc appointments where they just call somebody up, a friend or contributor or whatever, and tell them, hey, I've got a court appointment. But people still occasionally will come by, but it's a tight group. It's a tight group, and they do. I think, and I'm not real sure about this, but I think that they have to be qualified for the level of case that they're handling, but I'm not sure.
Well, they stopped the testing in Harris County.
Oh, did they?
They stopped the testing.
Oh, I didn't know that. I thought that they still had to be certified to take appointments. I know that some of the prosecutors, we've had this wonderful season in Harris County where Chuck Rosenthal has been exposed for the scoundrel that he is, and might I say, always has been, and was deposed, forced to resign because of his emails and the other assorted pornography, bad jokes, racist comments, etc., that were captured from his computer. And of course, the sheriff is under attack for the misconduct that his goons have inflicted on the citizens of Harris County. So we've got an interim district attorney who is an excellent interim district attorney, and frankly, if he were the elected DA, it'd be a good thing for Harris County, and that's Ken Magidson. But squaring off in November, we have Patricia Lycos on the Republican side and Brad Bradley on the Democratic side. And of course, Bradford, okay, goes show what I know. But the people in the DA's office are just fleeing their top level folks. Well, Kelly Ziegler ran for the Republican nomination, and when she didn't get it, she resigned because she knew she was toast. But the people in the top level of supervision in the DA's office are finding other things to do. And there are quite a number of felony chiefs that are, there's some certification school that you have to go through to get court appointments, and that's still true. But they don't have to take a test. They just have to show up.
Well, suppose, or have a number of trials.
Oh, okay. Get grandfathered in somewhere. Okay. Well, I know that a lot of these people are gearing up to become defense lawyers. It'll be funny. But, so that's what's going on with the court-appointed system in Harris County, getting back to court appointments or representing indigents.
You said something about the Harris County Criminal Defense Lawyers as you were past president of that organization. President. What happened in your tenure with them?
Well, as I said, we put together this attempt to make sure that we had competent representation of indigents with the appointments being distributed on an impartial basis in that pilot program that went for 90 days. And of course, we couldn't sell it as a permanent institution, so we tried that. I would say that you know, my immediate predecessor was Benny House, and then his immediate predecessor was Dick Guerin. And I would say that during my tenure, aside from that little pilot program that we did a lot of public service announcements, and this was an interesting thing too. It was, because the camera is something that stimulates people to an extent. We got some of the most conservative judges. George Walker, who was a Neanderthal. But we got George to be the judge for one of our public service announcements. And George, you know, we had a professional crew, spent some money on it. George loved being the judge on camera. Order in the court. And advertised, we put together, we had a referral list. And so we advertised on television using courtroom scenes with real judges, and then voiceover, Harris County Criminal Defense, you know, if you have a criminal law problem, contact Harris County Criminal Lawyers Referral System. And the way that worked was, it was a lawyer referral service, sort of similar to what the Houston Bar Association did, spin-off really of that, but exclusively criminal law. And at least if you were in the referral service, well, your name would come up maybe 3 times a year. You'd be on call, maybe for a week, 3 times a year. And so that was what we felt was a public service, and it also provided a benefit to our members in getting direct referrals. Once the person got the call, they just handled it like any other criminal, private criminal case. So we did that. We posted, we were able, during the time that I was president, we had the sheriff agreed that we could post boards, placards, whatever you want to call them, in the jail, Harris County Criminal Lawyers Referral phone number, so that people in jail would at least, you know, they wouldn't call a family lawyer for their criminal law problems. We did stuff like that, and then I threw one heck of a party and spent all the money on that. You gotta have some fun.
A lot of benefits you've mentioned to the members of the organization itself. I understand you did some recruiting of trying to be more diversified.
Absolutely.
Okay. Tell us about what inspired you to do that.
Well, and let's shift over to TCDLA now, because that's where that began to happen. I got involved with the Texas Criminal Defense Lawyers Association through George Luquette, who was a former president of this association. And George was killed in an automobile accident a long time ago, must have been in the early 80s. But George is the guy that got me involved in the Texas Criminal Defense Lawyers Association. And I guess TCDLA had been established maybe the year after I became a lawyer, or the year that I became a lawyer. I can't remember. When did TCDLA?
71.
71. So I became a lawyer in 1971. And I don't think I joined TCDLA until the mid-70s or so. I was focused on what was going on in Harris County. You know, I was working on, after 5 years, I was working on getting board certified in criminal law, and I was pretty, I guess you might say, selfish. I was concerned about number one. Although, you know, became involved in what I felt like were attempts to help criminal defense lawyers be better at what they do through the Harris County Criminal Lawyers Association. Of course, I left out the fact that we had seminars and other CLE type of programs in Harris County. But TCDLA was a much more well-financed, well-run organization, I would say, and one of the strongest programs that TCDLA puts on or sponsors is continuing legal education, which is why we're all here today. Rusty Duncan's a fabulous program. I come here every year without fail. But getting back to your question, you know, as I told you, when I began practicing law, it was a guy's game. There weren't any women. There weren't any blacks. There weren't. Well, there was. There was. As I can recall, when I started practicing law, there was one black criminal defense lawyer who regularly showed up at the courthouse. But over the years, all of that has changed, and so now, I mean, in Harris County, we've got 22 criminal district judges, and the majority of them are women. The DA's office has, what, 220 lawyers, something like that. Over half of them are women. You know, I had my little Rainbow Coalition law firm way back in '72 when that was an unusual thing. Now the courthouse is full of African Americans, Chicanos, women. Us old white boys are in the majority, or in the distinct minority now. And I might say that a funny comment was made by a young prosecutor to me within the last few months. He says, you know, the people that I have the biggest problem with are these old, grumpy, old white guys. I hope I don't fall into that group. But so TCDLA, Harris County Criminal Lawyers Association, when I got involved in TCDLA, again, it was a white male-dominated group. I mean, that's who we were. Tony Freelow, I guess, was our first president, or one of the very first presidents. And these were good guys, and they inspired me. I mean, I thought that TCDLA was doing good things, but it became a sort of a cliquish, small. I mean, the board was dominated by a bunch of chunky white guys, you know. So Jerry Goldstein preceded me as president of TCDLA. So he's president, I'm president-elect, and we felt that it was very important for the board of TCDLA to look like the courthouse, because the courthouse had changed.
And what year was this?
Well, I was president in 92, 93, I believe. So we're kind of late comers, you know. I mean, Jerry was right ahead of me. But we decided this needs to change. Our group needs to be more diverse. Our board needs to look more like the people we represent. We need to be reaching out here. We need to be actively recruiting minorities. We need to make our organization look like the complexion of the courthouse. We need women, we need blacks, we need Chicanos. And so we began, you know, each year you've got a turnover, and we began and felt that it was very important to diversify and to bring in women, bring in blacks, bring in Chicanos, put them on the board, bring them in from areas that were predominantly Mexican-American. You know what, I guess we had our first Mexican-American president, what, about 2-3 years ago, whose name I can't recall. Bobby Lerman. You know, so it's a long time coming to get to where we are now, but Goldstein and I felt that that was a very important transition that needed to be made. Now, you know, a lot of our friends didn't think we were very nice guys, but hey, what are you going to do? I don't think anybody spoke to me the whole time I was president. but that didn't hurt my feelings too bad, because I spent 6 months of being president of TCDLA in a federal trial in Houston, and Ron Goranson had to run the show. So, well, it all worked out. You know, I guess that. I feel like that's one of the more important things that I was involved in. Now, I had a non-legislative term, which makes life much, much easier for the president. I got to coast a bit, and that's why it didn't really cause any real disruption that I spent 6 months in a trial in Houston while I was supposed to be president. But other things that we did during the period of time that I was involved with TCDLA was the Voice for the Defense, which is a major benefit to the membership in terms of the case updates and the articles in particular, you know, because with the computers, which, you know, it's a whole new game at your fingertips. You can get whatever you want. So I think a lot of people have quit reading printed material, except for some of us old cowboys that are never going to give it up. But I think the articles are really important. Well, Voice for the Defense had kind of gotten, it had been under the same editorship for quite a number of years, and the individual who was editor at the time had done an excellent job, but had just gotten old and moldy. And so during my term as president, we replaced the editor of the Voice for the Defense and kind of revitalized that organ, which I felt was important. You know, those are the things that I did, I guess, for good or bad.
You talked about the fact that Kent is your partner.
He is.
How long is that partnership?
Wow. Schaefer and I have been together longer than we have been married to any of our wives. This is actually our 20th year. And of course, Kent was also a past president of TCDLA.
And your wife is Deborah? And
my wife is Deborah Gottlieb, and a hell of a leader. She and I began our relationship and ultimate marriage in the midst of another long federal trial in Houston, Texas. And she's always been a lot smarter than me, and so consequently, about 5 years ago, she retired from the practice of law and is now a very accomplished painter, and is really enjoying her life. You know, as she told me, it's up to you, big boy.
Now, you sort of did what successfully, what Bill did with Hillary. He asked her to do the health care plan, and you asked Deborah to do the CLE.
That's true.
And Deborah's CLE was much more successful than Hillary's health care plan.
That's true. Deborah did a good job. And in fact, she got involved in that before I became president, and was the course director for one of the big productions that TCDLA puts on. And so, yeah, she was very effective in that role, putting together CLE programs. Yeah.
When you talked about a couple of interruptions because of trial,
yeah.
This trial and that trial interrupted your presidency. Tell us a little bit about the trials that you had.
Well, over the years, that I've got 4 cases that really stand out, and they're unusual, each of them. I think I've done some things that maybe 1/10 of 1% of criminal defense lawyers have ever done. It's fun stuff. I was never a prosecutor. I was always a criminal defense lawyer, with 2 exceptions. I prosecuted Johnny Holmes when he was first assistant DA in Harris County in a show cause hearing in Justice of the Peace Paul Till's court. And this was during the time when Harris County was going to its current system of direct filing. There's a lawsuit that was filed against the Harris County Jail by an inmate that's called Alberti versus whoever the sheriff was back then, federal lawsuit, which resulted in an ombudsman being placed in control of making sure that the Harris County jail population stayed below a certain level. In order to effectuate this, some system changes were called for. You know, when I first started practicing law, a guy could be charged by complaint in a Justice of the Peace court and literally linger in the Harris County Jail for 1.5 years to 2 years before they ever set foot in a courtroom. It was abominable. It was the worst. And the jail was abominable. The jail was the worst. It was, you know, I'm sure there's a lot of bad things going on in Guantanamo, but I guarantee you that there were some horrible things going on in Harris County. Well, at any rate, to deal with that and try to speed up the flow of cases through the system and get people into court and get them magistrated and find out whether or not they needed to have a bond adjustment and see whether or not they had a lawyer. And the judges and the district attorney's office decided that they would institute a direct filing system, which has turned out to be a pretty good deal. Of course, this stepped upon and interfered with the jurisdiction of the justices of the peace who were invested in the examining trial process and very much jealous about protecting their jurisdiction. Direct filing happens like this. The complaint is filed, it's automatically assigned to a criminal district court, and that person appears in court within 24 hours, or if it's a weekend, the next Monday, and they are brought up in front of the judge, and the determination is made as to whether there's probable cause, whether or not the bond needs to be raised or lowered, and whether or not this person needs a lawyer. And it's all designed to get people out of the jail. They've even refined it further because now there's 4 magistrates working at the Harris County Jail, and these people are probable cause before they ever make it to the district court. They've seen a judge. In the 24 hours that they're waiting to come into court to see a judge, they've already been magistrated. They've already seen a judge. They've already read their rights. But back in, I guess, 79 or 80 when this was happening, big turf battle. And some Bel Air police officer went to Paul Till, JP, to get a search warrant. And Paul said, sure, I'm going to issue your search warrant, but you have to make your return to me and you have to file your charges in my court, which was the way it was done. You know, if you found some dope at somebody's house or stolen property or whatever it was you were searching for, you made the return back to the JP and you filed your complaint in the Justice of the Peace Court. Well, this was not the new program. You know, the new program was you bring your charges over to the DA's intake and they'll accept charges if they think there's probable cause. In that case, it's immediately assigned to a district court. So Bel Air PD sergeant, whoever it was, gets his warrant. goes out, runs it, and he knows he's in a bind here because he gets a telephone call from John Holmes, and John tells him in no uncertain terms, you either bring your charges down here, you bring your return to us, if you file a complaint with us, or there aren't going to be any charges. Okay, well, Judge Teal got wind of this. I get appointed to represent the great state of Texas in a show cause hearing as to why Mr. Holmes should not be held in contempt of court for interfering with Judge Teal's jurisdiction. The first thing I do is contact Bel Air PD and ask them to keep that. I know that incoming phone call from the DA's office was reported at Bel Air PD. So the first thing I do is contact the Bel Air PD captain and say, take that tape and preserve it. You know, this is David Bires. I represent the state of Texas.
Did you joke?
This is the first damn right I did. I've been appointed as special prosecutor. I represent the state of Texas. Captain, you take that tape and I want you to preserve it. We're going to have a show cause hearing in this matter. This is fun. You know, so sure enough, case gets set for a show cause hearing. For the very first time in my life, I announced ready for the state of Texas in ex parte John Holmes. Carol Vance, the then sitting district attorney, announces ready for the defense. Clyde DeWitt, his general counsel, is sitting next to him, and their client, Johnny, is sitting next to them. My first witness is Captain so-and-so from the Bel Air PD. Captain, you and I spoke back on such and such a day, and I asked you to preserve the tape-recorded conversation that was had between the defendant, Mr. Holmes, and Sergeant so-and-so. And did you do that? Yes, sir, I did. And have you been able to isolate or pick out that conversation that was had between Mr. Holmes and Sergeant so-and-so? Well, Mr. Bires, you know, we've searched that tape from one end to the other, and I don't know what happened, but we can't find that conversation.
So you had 18 minutes?
I glanced over, and Carol is writing a note to Clyde DeWitt. Appears as if we have a 17-minute gap here. Well, needless to say, we know I did invite Mr. Holmes to take a stand privately, to which he told me something very ungracious. So that was my first experience with prosecution, but subsequently...
Getting the verdict that you wanted as a defense
as a defense lawyer. That's right, that's right. I pray for these things, but, you know. Anyway, then some years later, and this must have been about 89, 90, I have a childhood friend who was a district judge in Corpus Christi, Texas, Mike Westergren. And boy, they were having a pissing match in Nueces County to beat all. And what happened, it's a very long story, but a district judge down there had a nephew. He got charged with capital murder. The judge was instrumental in the finding of the deceased body. Later on, in some proceeding or other, the cops felt like the judge crawfished on them. Well, in the meantime, there's a little internecine spat going on between a used car salesman and the first assistant district attorney of Nueces County. And the used car salesman is very upset that the DA's office won't take charges against some thug that's been regularly beating up on his daughter, but they won't take charges on the thug because the thug's a Corpus Christi PD snitch. So used car salesman gets a call from district judge who was involved in the earlier thing involving his nephew, and or at least gets a call from somebody who informs them that if you will go to the information booth on the first floor of the Nueces County District Attorney's Office, there will be an envelope for you. And that person does go and gets the envelope and opens it up. Lo and behold, it's the criminal history of the first assistant district attorney, which details all of his transgressions when he was a student at the University of Texas. It is also one of the worst kept secrets in Corpus Christi. Everybody knows about this stuff. However, seeing an opportunity to use some leverage, used car salesman calls up first assistant DA and says, "Ha ha, I've got you. If you don't file charges against this skunk, I am going to expose to the public in Nueces County your extensive prior criminal history." Whoa. Shortly, we have a district judge indicted. The used car salesman is indicted. And the sheriff is about to be indicted when my friend Mike Westgreen calls me up and says, "Bires, the district attorney's office down here in Nueces County is committing the offense of official oppression by restricting the free speech of the citizens of Nueces County, and I need a special prosecutor." Now, of course, he knew that no sane lawyer in Nueces County would come within a mile of that, right? You know, I guess out of our old friendship or whatever, I agreed to take on that job, which spawned State of Texas versus Grant Jones, District Attorney of Nueces County, Texas. As we convened a court of inquiry, the DA's response, of course, the DA's response to that was to bring in a prosecutor from North Texas, appoint him as a special prosecutor, and the day that we were to convene the court of inquiry, special prosecutor, I think Jerry Cobb, calls me and says, "I'd like to meet with you and talk about this." And the meeting was at the DA's office. In the meeting, I know that that meeting was being surreptitiously recorded. And I know that basically Special District Attorney Jerry Cobb was looking for a basis to indict me and Judge Westergren. So this called for some very tactful negotiations. And what we agreed was that I would step back, and this is in consultation. I'm kind of running back and forth between Cobb and Judge Westergren. Agreed that we would stay our court of inquiry and give Mr. Cobb an opportunity to review the grand jury proceedings that had resulted in the indictment of the district judge and the car salesman and the near indictment of the sheriff. And so I agreed, okay, fine. I'll give you some room to operate. So we kind of stayed things. Well, he goes back in and unindicted everybody. I mean, he represented the cases and unindicted everybody. And then we reinstituted our court of inquiry because the matter had not been settled. The DA's office filed a writ of prohibition, I believe, and the Court of Criminal Appeals had to agree with us that we were, that Judge Westergren was certainly entitled to proceed with his court of inquiry. And that case ended in a consent judgment where the district attorney's office and I entered into an agreement that in the future, when any member of their staff, any lawyer on their staff was the complaining witness in a criminal case, which happened to be the first assistant DA was the complainant against the car salesman and the judge for retaliation, that they would recuse themselves, bring in a special prosecutor, abide by the rules of professional responsibility, and so we tied a neat bow around it. That was it. A couple other cases that I think are noteworthy. There was a case, Collier versus Poe. I represented a guy named Collier. Collier was charged with the attempted murder of his wife and her daughter. Collier had been an electrician in Matagorda, the nuclear project, South Texas nuclear project, and he was putting his wife through nursing school. And the day that she graduated from nursing school, she emptied all the bank accounts, changed the locks on the house, and basically he got tossed out. This didn't sit well with Mr. Collier. And so, being the electrician that he was, he went over to his house where his wife and his stepdaughter were living, and cut all the wires going into the place, kicked the door down, and there ensues a gunfight, which he shot his wife in the stomach, shot his stepdaughter through the breasts, and he was shot in the head. So it's just a great little gun battle going on inside this house. Well, Mr. Collier is charged in Ted Poe's court, and Ted had a rocket docket, just a fast-moving docket. And literally, Collier's first appearance in court was in a wheelchair with his head all bandaged up. He looked awful. He'd just gotten released from the hospital and had come straight over to the court, and he was messed up. And so we get set for trial. Just that there's no compassion or empathy from the court. It's a round. Yeah. Well, it so happened that trial setting sort of coincided with a period of 30 days prior to the institution of a legislative session. And I decided that I needed the assistance of a well-informed counsel with considerable experience, and so I hired myself a legislator to provide me with that invaluable trial experience that she had. And we filed our motion for a legislative continuance, kind of stop this, or at least slow this train down a little bit, at least give my guy a chance to recover from his gunshot wound in the head. And of course, we all know that if you file your legislative continuance and everything's in order, it's a gimme. It's got to be granted. Oh, no. Judge Poe convened a hearing, a little unusual. And at that hearing, the state called witnesses, the wounded wife and the wounded stepdaughter, and using a family law theory that if a legislative continuance will cause inconvenience to a party, it can be denied. And he promptly denies my motion for a legislative continuance, and we're supposed to start trial the next Monday. So very promptly file a motion to stay the proceedings in the trial court, file a writ of mandamus, and my then office mate, Phil Green, just thinks Bires has screwed the pooch, and I'm going to ruin it for everybody, But the Court of Criminal Appeals agreed with me, and my mandamus was granted. Collier versus Poe preserved the sanctity of the legislative continuance. And because Judge Poe had actively conspired with a certain high-ranking officer in the Texas Criminal Defense Lawyers Association, who will go unnamed, in order to try to defeat my motion for legislative continuance. As soon as the legislative session was over, I went in to see Judge Poe, handed him my motion to recuse him, and basically told him, look, I'm going to file this. If you don't want me to, well, why don't you just agree to recuse yourself? And he looked at it. He said, well, let me think about it. And his offer of compromise was, well, how about if we transfer this to Judge McSpadden? No! No way! Put the little ball in the hopper and let's see where it falls out. And so we fortunately got them to abide by their own rules, and we wound up in front of Charlie Hearn, and about a year later, everybody kissed and made up. Mr. Collier got his 10 years probation, and everybody left the courthouse happy.
And Charlie signed the judgment with his happy face.
That's with the happy face.
With his
there
happy
you go.
face, okay.
One last thing. I found I was representing some guys from Dallas in a district court in Houston. Woody Denson was on the bench. Woody is not the sweetheart of the criminal defense bar, as you well know. Harris County Criminal Lawyers Association is trying to bar him from ever sitting in Harris County again, and filed a Judicial Qualifications Commission complaint against him, which the so-called Judicial Qualifications Commission sort of promptly brushed aside and found that Judge Denson had not committed egregious acts when he went ahead and took a plea when a lawyer wasn't there, and also told somebody that he was going to put them back in jail because they hadn't hired a lawyer or something like that. Woody and I used to office together many years ago, but you know, HCCLA's point is well taken. But nonetheless, back when Judge Denson was an elected judge, I represented some guys, a group of guys from Dallas, and I forget what the procedural vehicle was, but I challenged the constitutionality of the hey, rock and roll. And we're going to wrap this in a minute. Okay. Ready? So anyway, I forget exactly what the procedural vehicle was, but nonetheless, I filed a challenge to, it may have been a motion to declare the organized criminal activity statute defenses excluded provisions unconstitutional. And in a hearing before Judge Denson, which was characterized by the then prosecutor Jim Levine to his narcotics officers, this is just a slow plea of guilty. Well, Judge Denson granted the motion, declared the provisions unconstitutional, and the case was ordered dismissed. And the state filed a writ of mandamus or prohibition or something against Denson, challenging his authority to declare the provisions of that statute unconstitutional. And fortunately for my client and his friends, the Court of Criminal Appeals found that in fact the district judge did have the authority to make such a ruling, and that was the end of that. And thank you very much, Jim Levine. So those are some of the fun cases. Other than that, I've been a criminal defense lawyer for 37 years, and I've tried everything from a traffic ticket to the most horrendous capital murder case you think of. And David Cunningham and I tried a capital murder case that originated here in San Antonio. And this is how bad this one was. Here we are in Bexar County. Can't really be a much better place to try a criminal case, in my opinion. We represent a guy in a capital murder case, General Robert Bires, and General of the Mexican Mafia. And we filed after Robert, the capital murder case had been filed, and then about 9 months later, and 2 weeks before we were supposed to begin jury selection, Robert and a bunch of his friends all get indicted in federal court in a federal RICO prosecution. And for 2 solid weeks, all you hear about in San Antonio is the Mexican Mafia and General Perez, and basically detailing everything that they're going to use against us in our capital murder trial. So naturally, we had to file a motion for change of venue. And we wound up trying that case in Dallas, Texas. Oops. Anyhow, practice of law has been very, very good to me, and after 37 years, hey, I can keep on going.
Thank you, David.